Hello friends, in the series on the income tax cases, today we will issue a very important point which has been discussed by the Jharkhand High Court in the present case. The issue is that when show cause notice under section 148A clause B is being issued by the jurisdictional assessing officers to the assessee, in section 148A clause B there is a clause or there is a wording that not to be less than 7 days time to be given to the assessee to reply. So what does this clause implies? Sometimes the question arises in the mind that whether the date of issue of notice and the last date of submission of the notice is to be excluded from this time. So this issue has been discussed in the present case. The name of the case is Satish Kumar versus Principal Commissioner of Income Tax and another. And this case has been reported in 459 ITR at page number 67. The date of the judgment is 28th August 2023. In this case, the show cause notice under section 148A clause B is issued to the assessee on 22nd March to give the reply on 29th March. So if we see section 148A clause B, then the assessee was given only the time of 6 days, that is in between 22nd March to 29th March, that is 23rd, 24th, 25th, 26th, 27th and 28th. Because in this case the Honorable Jharkhand High Court said that when the section says that not to be less than 7 days, it means that the clear 7 days time should be given to the assessee to give reply. Minimum 7 days to be given means that the date of the notice and the last date of the submission should be excluded in calculating those 7 days. This was the one issue. In the present case, although the last date of the reply which was given by the assessing officer to the assessee to give the reply was 29th March, the window to e-reply was closed on 26th March, and accordingly the assessing officer issued the order under section 148. Simply meaning thereby that the assessee was prevented from supplying his reply. Since the notice was issued, so the assessee filed a writ petition in the Jharkhand High Court against this notice under section 148. The court said that in the present case the assessee has submitted the screenshot of the portal that clearly reflects that the portal was closed on 26th March. Although in this case the department came with a view that the assessee should have approached the appropriate authority in case the portal has been closed. So the court said that it is not the duty of the assessee to approach concerned authority, and if the department takes such a stand, that stand is misconceived and without any basis and deserves to be rejected in limine. The best part on the part of the assessee was that the assessee took the screenshot. It shows that nowadays how vigilant the assessee should have been, because if the assessee should have not taken the screenshot, then it would have taken a longer period to prove his point that the portal was closed on 26th March 2023. And the department was expecting that the assessee should have approached the concerned authority. My point is that what is the concerned authority in this in these type of cases? If the portal is closed, then the assessee will have to rush to the jurisdictional assessing officer. Then what will be the meaning of this faceless assessment? At the end, the Jharkhand High Court quashed the notice under section 148 and remanded the matter back to the assessing officer to give clear 7 days time to the assessee to reply. Friends, with due regards to all the high courts, my pray is that in these type of cases, when on the pursual of the bare reading of the section, it is clear that minimum 7 days time is to be given and the assessing officer does not give this time and even closes the window before the time which has been given by the assessing officer, then in those cases a heavy cost should be imposed on the assessing officers and the second inning should not be granted, because until and unless this remand back will be stopped, the assessing officers will take very lightly in issuing the notices, and the principle of natural justice will be kept at the below the carpet. At the end of this video, once again I am repeating the name of the case. The name of the case is SATISH Kumar versus Principal Commissioner of Income Tax and another, and this case has been decided by Jharkhand High Court. The matter has been decided and reported in 459 ITR at page number 67.